Hello, everyone, and welcome to Moving Criminal Justice Online, Challenges and Opportunities for Young Attorneys. It's a non-CLE webinar co-sponsored by the ABA International Law Section's Young Lawyers Interest Network and the Criminal Justice Section's Young Lawyers Committee. I will introduce today's moderator and then turn things over to her to get the program started. So today's moderator is Kelly Blunt. Kelly Blunt is a doctoral researcher in criminal law at the University of Luxembourg, where she focuses on the cross-jurisdictional uses of artificial intelligence in criminal justice, specifically by law enforcement. Kelly is a graduate of Rutgers School of Law and New York University. She's an attorney licensed to practice in New York and New Jersey. Kelly is the co-chair of the International Law Section's Young Lawyers Interest Committee, as well as vice chair for publications on the International Law Section Middle East Committee. She's also on the editorial team of the Journal of Law and Cyber Warfare and is a judge for the Jessup International rounds of Jessup International Moot Court. So take it away, Kelly.
Thank you, Kristen. I also want to thank the Criminal Justice Section for hosting this, and specifically Deanna Adams, one of the co-chairs of the Young Lawyers Committee who helped to put this program together. We have a great lineup today. I'm very excited to hear each of our speakers. I'm going to introduce each. They'll talk for about 10 to 15 minutes on their experiences practicing during COVID. And then at the end, we should have some time to answer questions and have a discussion. So like Kristen said, please feel free at any time to put your questions into the chat. Our first speaker is Elizabeth Rosen. Elizabeth is a felony prosecutor with the Howard County State's Attorney's Office in Ellicott County, Maryland. She attended law school at the University of Maryland, where she completed internships with the Department of Justice, Department of Homeland Security, and the Office of the Public Defender. Elizabeth currently sits as a vice chair of the ABA's Young Lawyers Committee for the Criminal Justice Section. She also serves as the current chair of the Maryland State Bar Association's Young Lawyers Section. Whenever you're ready, Elizabeth.
Thank you very much, Kelly. Good morning to everybody on the East Coast, and good afternoon and otherwise to all of our friends everywhere else. Like Kelly just said, I handle felony trial work in Howard County, Maryland, which is a kind of a suburb between Baltimore City and DC. And so what we tend to see frequently is the kind of the overflow from those jurisdictions. So while we might otherwise be known as a quieter area, what we have seen during COVID is a significant rise in violent crime. What I can tell you is that our general flow of our trial work has basically tripled. My caseload has tripled over the course of the last year and a half, which is to be expected because we're in a significant backlog of cases. Majority of the cases that we have, speedy trial is a real thing, and we try to get all of our cases flowing as quickly as we can. But what we're seeing now is that, we have cases that are easily 2 years old with defendants who are still incarcerated, who haven't had an opportunity to be heard in substantive hearings. We're hoping that that's going to be alleviated soon, but what we know is that public defenders are already overworked, prosecutors tend to be as well, and when I'm telling you that my caseload has tripled as a result of COVID, that's a real strain on the criminal justice system locally that we're feeling pretty much every day. Because of that, what I found is that I rely on paper trails more than ever. What I mean by that is I have to we always take good notes, but now you're relying on those notes. Every conversation that you have with a defense attorney, witness, judge, it's all going into our system, and we're having to reflect more on those because these cases are aging, and you need to remember all aspects and the minutia of those hearings as you go on and as you're getting more and more new cases with that caseload getting heavier. What I found also is that I'm in court way more often than I was in the past. Like I said, Howard County we had a little bit of a sleepiness to us, but that's really no more. I would be in court probably about 3 to 4 days a week, but now certainly I plan to be in court every day, and that's on all different kinds of hearings, whether it be from a bail review to a post-conviction type of proceeding. Howard County, the state of Maryland generally, actually today is the first day since a brief period in November that we've been allowed to return to jury trials. So ironically, our judges are in a judicial meetings this week, so we are not having any jury trials this week. But starting next Monday, we will commence jury trials once again. There was a brief time in November when our highest court allowed for jury trials. That lasted for only a few weeks, and then we have not had jury trials since March of 2020. So it's really been quite some time. But what you see still in terms of the workflow that we have is that people that are in jail are clamoring to get out, and those that have never been held on bond are looking to postpone those hearing dates. And what that's done is created sort of a impasse in terms of plea negotiations, because unless you're incarcerated, we're really not hearing too often from defense attorneys about trying to resolve cases. And that's fine. It's, it's a natural consequence of the circumstances that we're in. But now that we do have that date certain for the return to jury trials, and hopefully that will stick, as in we'll be able to start a return to normal, to consistent jury trial practice, we'll be able to see some of that tripled caseload start to return to a more average amount. What I'll say is that we've also had delays in sentencing. If we are able to reach plea agreements, the court, in my experience, has been unwilling to sentence defendants to jail. So we've been postponing sentencing hearings, and that's happened several times. If we reached a plea back in October of 2020, if we're still asking for incarceration, our court, as of now, pretty much today, will start allowing us to go to sentencing and let the state ask for recommendations of incarceration where that's warranted. We do a lot of collateral proceedings. If you are convicted by a court trial, a jury trial, or you were convicted, or you entered a guilty plea rather, there are collateral proceedings available to you. And those hearings have been very, very difficult to do virtually. So those defendants that are filing for that kind of relief, that can include motions for reductions of sentence. We have 3-judge panels in Maryland where a judge who did not hear the original conviction, 3 judges can sit and review that sentence. Those hearings have really come to a standstill during COVID, which is very frustrating, I'm sure on both sides, but we're looking forward to getting those back underway. In terms of access to technology, that of course is a huge, huge item for the COVID era. It's a huge issue for pro se litigants and litigants who don't have access to the internet. We can't expect them to participate meaningfully if they don't have access to the internet, to a computer. Sometimes, they might have access to internet, but the internet is really poor, and so it's not a meaningful engagement when we do try to hold hearings virtually. In Howard County, what we've done for the most part is that if you are a pro se litigant, you will have to come physically to court. So I go to court, anywhere physically 3 to 5 days a week at certain hours to have in-person pro se litigant hearings. But one of the problems that we're having is certainly the pandemic has resulted in a lot of people losing their jobs, which means that some people are in unstable housing. So if we're mailing you a notice to an address that is no longer yours, how can we expect pro se litigants or other litigants to appear in court, whether it's virtually or in person? That's been a big issue and causing a lot of delay, because it's unfair to a pro se litigant or defendants who aren't receiving notice to expect them to appear in a hearing that they don't know about. So that goes hand in hand, certainly with access to technology. It's also a different environment when we work in technology and Zoom. I've had Zoom hearings where defense attorneys forget that we have court, and so they're in their cars, Zooming from their cars because they want to be there. People wear things that you might not expect. Certainly everyone's seen some of the videos that have come out about people appearing virtually, and it's funny sometimes, but you do lose kind of that, I'm going to call it decorum for the court, which I do think is really felt strongly. Criminal matters especially, they're very serious, the consequences are very real. And so, I do think that a little bit of that is lost when we do resort to virtual court. One of the things that I've noticed a lot in my litigation that I've done virtually during the pandemic is there is a significant impact on your ability to judge credibility of witnesses, of defendants, when you conduct proceedings remotely. I think that seeing people, the right of confrontation, I know is it's just different during COVID, and that's something that we're all working with. But I do think something is lost when you can't look at someone physically in a courtroom. And I know we're all doing the best we can, but that's definitely credibility is a huge part of the criminal law practice, and that is something that I'm constantly seeing in the litigation that I do virtually versus in person. There's a lot of issues interacting with defendants that are incarcerated in a virtual capacity during a pandemic. If your client is in quarantine, it's very difficult to get a Zoom meeting with them or an in-person visit, and that directly affects defense attorneys' abilities to do their job, the ability for me to do my job. In-person visits have been heavily restricted. Not all of the jails in Maryland are cooperative with virtual visits, and part of that tends to be they don't have the resources for it. Maybe they, some jails have done video bail reviews for quite a long time, and so they're better suited to have these visits. But we're moving a lot of people. The jails have a lot of people, and now we have to create all kinds of scheduling and make sure that everyone can be handled safely in terms of exposure and in terms of just getting people where they need to be in a arena to meet with their attorneys meaningfully. Especially, if you're trying to review evidence with a client, doing it over Zoom, I don't think it has the same impact as if you go in person. One of the things we were asked to think about is whether any of the accommodations will stick in terms of social distancing. I will tell you all, I work in a historic courthouse. It is several hundred years old. It was not made for social distancing. The court has been more accommodating with allowing witnesses to appear remotely, which can be great for people that are high risk or experts that might live out of state in terms of cost to the person that's putting them on. But for us, we have 5 courtrooms. Only one of them is suited for social distancing. That being said, our juries have to deliberate in that courtroom. They can no longer be sequestered in the same way in a smaller jury deliberation room, which means that the rest of the dockets are impacted because we're losing that courtroom for the jury. As a younger lawyer, I definitely think that working in this time impacts young lawyers differently. Young lawyers come to the court with, it goes without saying, with less experience. So not only are young lawyers have to embrace the challenge of learning Zoom and learning to file exhibits through, whatever electronic function the court requires, but they're also trying to understand the arguments that we're making and how best to do that. So you're really having to balance a lot of different things here with understanding a virtual realm. So, I definitely think that that's something that you guys should keep in mind when you're doing that. You want to not only be confident in the legal arguments that you're going to be making, but also confident in how you're going to do it through an electronic atmosphere. We're also looked at often if things aren't going well with technology. People always assume that a young lawyer knows how to fix the issue. I can tell you that computers, I try, but that's all I can give you is my best effort. It also affects young lawyers in terms of building relationships. When a young lawyer starts in a criminal defense practice, a prosecutor practice, we're looking to network, to learn from other people. It's very difficult to learn from other people when the attorneys around you are in Zoom hearings that you're not a party to. We don't have that same camaraderie in the courtroom or in the hallways, but we can see people maybe we haven't seen and start building relationships. You're waiting for your case to be called, you're talking to somebody you might never otherwise talk to. That's a real loss to young lawyers. The good news is we still have time. We are young, we still have time to build those bridges, but I definitely think there's a disadvantage for young attorneys being able to be exposed to good lawyering and bad lawyering and learning good habits and just seeing different types of hearings that we lose in a virtual environment. But there are silver linings to using more technology. I know it's hard when you're in trial and you have to make 13 copies for the jury or enough copies for people. When you're filing your exhibits online, you don't have to worry about that. You can do that from the comfort of your own home. Speaking to people that are in other jurisdictions is easier. I do a lot of jail violence, so I have victims that have been moved to all over the state, and when the jail lets me do virtual visits, that saves me time. Chances are I can't get to that county in person, so that's really great. Technology can also be a great tool for argument. There are many prosecutors who use PowerPoint regularly. I am not that person, but knowing the environment that you're in might make you realize that maybe this was a skill set that is actually really beneficial to the type of case that I'm doing. I know also, speaking to victims that live out of state, there are many people who, as a result of the pandemic, have relocated. So Zoom has allowed my office to communicate with people who are out of state, out of the country. That's far better for just health precautions, but also in terms of efficiency. I have a victim right now who lives in El Salvador. Chances are they're not coming to America anytime soon for a whole host of reasons, but we're able to communicate with them over Zoom, which has been really productive. I don't personally have any experience with jury trials during the COVID era. Like I said, we had a period in November where we got 2 jury trials off the ground. We are in a position still where even though we're back to jury trials, we will have 1 a week. That is all my courthouse can accommodate. That is a really difficult thing for defendants, for their attorneys, for the state in terms of trying to clear some of this backlog, knowing that we can only accommodate one jury trial a week. So that's just how it's going to go. Well, I just want to touch on really quickly the stresses of remote work. I'm actually back in office. We have been back in office full time since the beginning of April. And what I will tell you is, having seen now both sides, working with many people who are still working from home, is that one of the realities for me is we don't normally have court virtually at all. So I have coworkers now who can be in litigation and everybody else does not. And you know, the noise around here, like you really have to be aware of who's in court and who's out of court, what you're saying, because people outside your door, if they say something and it's picked up on the court recorded hearing, you know, it's not great. But one of the things that I was talking about with Kristen before we started this is boundaries. Boundaries are a real thing, especially for young lawyers. We are always expected to be on and available, whether you're working for a partner or for somebody else. And the reality is that you still have to set boundaries. I come to work. When I leave work, if something's not on fire, please don't call me. Because if you're just available, people will take advantage of that. I had to give my cell phone number out during the pandemic to be able to speak to attorneys and different things. And I still get calls. I'll be on my lunch hour and I'll get 13 calls from different attorneys. So just make sure that you're aware that it's okay to have some time to yourself. Even if you're not in a physical office, making time for yourself is really, really, really important. You can still be successful, efficient, but you got to make sure that at some point, if it's not urgent, that you can let it wait until tomorrow. And I think that's really where I was going to start. Kelly, I didn't know if you wanted me to touch on anything else.
No, that's perfect. Thank you. You've raised a lot of very interesting points. I think the setting of boundaries, it's always nice to be reminded that it's okay, because I think it's difficult, especially being at home. So next, I would like to introduce Joshua Dreitel. I'm very interested to hear the defense side of how this is all played out. Obviously, Elizabeth has raised some of the difficulties that I'm sure are affecting you as well. Joshua is the founder and president of Joshua L. Dreitel PC, with more than 32 years of experience in practice. His experience includes defending individual rights in complex federal and state cases, such as those involving RICO, mail fraud, tax and security issues, national security, and many others. Those cases include the investigations and prosecutions of major construction companies, a telecommunications giant, the 1998 bombings of the US embassies in Kenya and Tanzania, and representation of political and business leaders. Joshua is a past president of the New York State Association of Criminal Defense Lawyers. He is a member of the Capital Punishment Committee of the Association of the Bar of the City of New York, as well as the association's Task Force on National Security and the Rule of Law. He is a frequent writer, lecturer, and speaker on a wide variety of criminal law and national security topics, and his articles have been published widely. Mr. Dreitel graduated magna cum laude from Columbia College and from Harvard School of Law. Whenever you're ready.
Sure. Thanks, Kelly. Thanks, everyone, for joining. Thanks to my other panelists. Already great presentation by Elizabeth, who raised a lot of issues that I don't have any disagreement with. I may reaffirm some of them from the defense side, also because the orientation is just a little bit different sometimes, particularly in the context of a practice that doesn't necessarily rely exclusively on trials and volume, in the sense that I don't try as many cases as a state prosecutor or a state public defender would, because if you look at the numbers, so many people plead guilty, 95 to 97% of people plead guilty, particularly in the federal system, that a lot of it is managing cases and what happens before a resolution. But COVID has obviously been an extraordinary development in terms of interrupting the normal course of criminal defense and the criminal courts. One of the topics that Kelly circulated was the flow of trial work, and I would say it's a dry riverbed at this point, because as Elizabeth noted, there really aren't trials. There was a short interval in the fall, September, October maybe, where they tried to get some trials going, and they had a couple, but that was very short-lived because of the surges in cases, and also just the inability to keep the environment safe in the courthouses. This has all been done by baby steps, trial and error. We're back now since February, March in the federal system, at least in New York, in terms of trying some cases. They've tried a few, but they can't handle extraordinary volume. There's maybe one going on or maybe two at a time in a very large courthouse. You can't get jurors in at that volume to be there. There's too much traffic in the courthouse. Also, the number of defendants is limited. Right now in the federal courthouses here, you can't have more than a 2-defendant trial, which limits the options in federal cases, because in federal cases, multi-defendant trials are quite common. So that's created a significant backlog that unfortunately is probably going to inundate the courts in the fall and the winter and next spring in a way that I don't know how that's going to be handled, because they're already queuing up cases that are queued up for 2 years now. You know, I had a case that was supposed to go in February of 2020. It got pushed to June because of some discovery issues, but then June 2020, and then now it's October, and we're meeting with the judge this week to determine whether October is viable, because there are 3 defendants and because of it's 8 weeks and you know, it's an 8-week trial. So all of these things have an impact, and everything will get pushed back, and there will be an extraordinary, I think, volume of cases that people will have to handle. And I don't know what that will mean in terms of what prosecutors will do in terms of their flexibility with respect to offers, whether defendants just want to get cases over. They've been languishing in virtual solitary confinement for 13 months. It's been extraordinarily difficult to keep those relationships intact, not just because of the inability to get there to visit for such a long period of time, but also because of their own isolation separately. It's very, I mean, for all of us, the stresses that we have had in being restricted in movement and sort of self-quarantining in some respect, when you think about what it's like, what life is like incarcerated, and to go through that is a very, very difficult, for the duration that we've had. It's a very, very difficult existence to endure for incarcerated people. So that's a hard part of this, is maintaining relationships. It's taken a different context in terms of trying to do it by video, by phone, by trying to create a rhythm of contact through email and phone and video that keeps in touch with a client. Some new cases that have come in, that's even more difficult. It's really, I've had to concentrate on what the elements are that we take for granted in creating a relationship of trust and confidence between attorney and client. And that has required some additional work and some additional thought in terms of trying to accomplish. We do this ordinarily, but it usually happens in the course of a relationship in a very organic way. But here you have to make the additional effort. And this is one thing for younger lawyers, is to try to accomplish small things, even if they're just small things, for your client as quickly as possible. Because the ordinary way that a client gets to trust a lawyer is just not available right now. And accomplishing things, think of it, you know, I go back to cases involved where clients were in solitary confinement or under what federal system special administrative measures, which limit their capacity to communicate with the outside world, and the lawyer becomes the exclusive conduit for that. Then you realize the kind of things you have to do, and you sort of go back into that mindset as to how to communicate with a client and build that relationship. For younger lawyers, it's hard. I agree with Elizabeth. The networking part is difficult, but also, if you know, when I first did an arraignment or when I first did a bail hearing, then it actually that bio is a little old. It's like it's 40 years ago now. But when I did, you know, I could ask someone. I said, what do I expect? And they could tell you, well, here's the liturgy between judge and lawyer, judge and prosecutor, judge and defense lawyer, judge and prosecutor, client and lawyer, and you can get a sense of what's going to happen. What we have here is unprecedented, and it's difficult to advise younger lawyers as to what to expect. I did 2 Second Circuit Federal Courts of Appeal arguments on the telephone. I had no idea what to expect. I did one by Zoom later on, where they finally set up a video version. I really didn't know what to expect. They all were surprisingly consistent with what I was used to, but that comes from a lot of experience. I'm not sure that that's something that you pick up as your first argument. So not knowing what to expect was always terrifying for me as a young lawyer, and I could see that being a significant issue now. But the other side is it can be liberating not to have rules and traditions and things that confine you as a lawyer. So go in with what you want to do and see if you can accomplish that. You know, in these trials now, it's all new to everyone, to judges and to witnesses and to your adversary. So thinking imaginatively and innovatively is very important and can be very valuable for younger lawyers. I think older lawyers tend to want things to be exactly as they were, as what we're used to. That may not be the best way. You may find advantages in this situation, in this environment, that you should exploit and you should capitalize and you should try to incorporate them. You know, judges don't necessarily have the answers because this is a new template for them as well. So I would be a little more aggressive in that regard if I were a younger lawyer. If I don't see something that's satisfactory, or if I want to change something, I think suggestions are welcome in most instances, because the idea is to, you know, try to replicate not necessarily the way a trial operates, but to give the defendant a fair trial. You know, I worry about jury composition. I worry about jurors behind me. You know, when, you know, if there was an article in the New York Times over the weekend about the new physical configuration of the courtrooms in the Southern District of New York, and those, it takes some adjusting for those of us who have a way of performing in the courtroom. And it's different. You know, do I want to communicate with my client on a telephone in the courtroom? No. Do I have to learn how to do it? If we're going to try a case under these circumstances, yes. I've taken a plea where I've done it. And again, it was not as bad as I imagined, fortunately. But at a trial, it's a bit more, because, you know, the jury's watching you communicate. All these things go into, you know, why did he ask a question on that answer and not the other one? Does that mean that's false and the other one's true? There are all these dynamics that you try to prepare a client for when they're sitting right next to you, and they can write a note or they can do something that's inconspicuous. Now it's more conspicuous. I think it's harder in that regard. In terms of also in terms of younger lawyers, when I was a younger lawyer and I would go to have something that I hadn't seen before in a courtroom or some experience, and nobody else seemed to be bothered by it. It was like, oh, maybe it's okay. Maybe this is the way it's supposed to be. I shouldn't say anything. In this context, don't let that be a deterrent to speaking up, because no one knows what's normal or traditional in this context. You have to be, again, a little bit more assertive in objecting or questioning, why are we doing this? Why don't we do it a different way? Or what's the advantage of one way of doing something versus another? And I think those are really important to keep in mind. What will last? I think that, and this is hard because it's a balance that has to be achieved in terms of client visits. If I could talk to clients on the phone on a regular basis and do video, it will save an extraordinary amount of time. For every visit I go to a federal detention center, I spend twice as much waiting for the client as I do with the client. I have to go in person, I know that, but if I can keep in touch with a client and cover some ordinary things by video or phone, it actually would be an advantage. I think also there'll be some remote proceedings that will stay, and whether that's good or bad really depends on the specific proceeding and the client. I know some clients who don't like to be dragged out of the prison at 6 a.m., sit in a freezing room for 5 hours for a 15-minute court appearance. That's just an adjournment. They prefer to stay back, do their work assignment, go to the library, you know, have their normal routine. That may be an advantage. So these are things that we have to consider going forward. I don't think trials, obviously, you know, and there haven't been, as far as I know, in most places, successful criminal jury trials in the context of a remote proceeding. Although I think Texas may have tried some, but there are, I agree with Elizabeth about the immediacy of being in person. I've had the opportunity to do some civil depositions during this time period, and I will say that I'd much rather defend them than be the questioner during this period for a couple of reasons. One of which is no one's going to sit for 6 hours like they would in a room on a Zoom. It's just not going to happen. Your client, if you're the witness's lawyer, your client's going to get a shortened version of what might happen in person at a, in a conference room where everybody's committed to, like, all right, we're going to be here today. We're going to break for lunch. We're going to break for coffee. We're going to break for bathroom, but we're going to be here all day. On a Zoom, I haven't seen that occur yet. The other thing is, I think there, again, that rhythm between a questioner and a witness and the ability to read cues is harder on Zoom. One thing that is easier, I think, since usually these depositions are all recorded, is that sharing screens, so instead of like pointing to a document, say, can you read line 7? And, you hear line 7's on the screen, it's recorded. Doesn't it say X, Y, and Z? And the guy says, oh, doesn't it say, so you can be more effective in that way. But and for defending it, if it's a delicate deposition, I'd still rather be there in person, despite what I said earlier, because the nonverbal cues between you and your client are completely eliminated on a Zoom. Like, I can tell when a client is getting anxious about a line of questioning, and I can tell when a client sneaks a look at me, and I know, okay, we need a break. It's harder in this context, and it's also less reliable in terms of what I'm reading from my client. So you don't want to step in inadvertently, but you don't want to lay back and let something get out that, and for me, depositions are usually really about the Fifth Amendment, because I don't handle a lot of civil cases. It's really about protecting people in the context of a parallel criminal investigation. So in that context, I'm always alert to that, and it's harder in this environment. For younger lawyers, one of the things about, I think generally they're more comfortable with electronic communication than older lawyers, just generally, although not the phone. I know the phone is clearly out for the youngest lawyers. Part of, and what Elizabeth said is true, is part of being available all the time and everywhere. So in other words, if someone says, hey, would you like to teach my class in Chicago? You can't say, I can't make it to Chicago tomorrow. They say, yes, you can. So there goes 8 to 10 at night. That's it. If you've just blown it, and and they know you don't have anything to do, so it's difficult. But you have to maintain the work non-work balance in some way and create those boundaries, even if it's in the middle of the day, because now with time being so flexible, if you want to take between 2 and 3 to do something else, you should do it. You should maintain that. You should make sure that this doesn't overwhelm all of your senses, so that you're not getting stimulated by other parts of your life. And that's important, whether you're in a relationship or alone or whatever, whether it's with kids or spouses or others or friends. It's important to maintain that as a balance, and it helps your work too. It just does, to give you a sense of other contributors to your frame of mind and to your perception and all of that, and to your mood. So that's important. I think also that and this is hard, but from experience, I say it, which is the most, if there's one piece of advice I would give to younger lawyers, is don't worry. Don't worry about how this is going. Don't worry about where this is going for you. Don't worry, because that doesn't really help. It just adds to your stress. It's not necessary. Everyone is worrying about their situation. And when this resolves itself over time, you will have an experience that will give you confidence that you can get through really hard times and really difficult situations. And that's extraordinarily important going forward. And the other part is that, it's, I try to tell clients, don't worry, or be normal in your life as this is going on if they're out, but I know that you will have moments of panic where you'll say, I'm not being normal. My lawyer told me to be normal, so now I'm not following my lawyer's advices. It will go back and forth in that regard, and you'll just have to weather it as best you can with the resources that you have personally and in your relationships. That's, and the other part is, the silver lining. Silver lining to me, there's another thing that Kelly floated for us, silver lining for me is that this has punctured the self-importance of lawyers and courts and all of that and the whole system. The world can exist without us. It has gone on without us to a major extent. So remember that when you're thinking about, again, balance and other factors, and just in terms of forcing others to be as unreasonable as others are being to you. So in that regard, it's always good to have that on both sides, is to not make the demands that you don't want made of you, and to remember that this is what we chose to do at a certain extent, and we do it for the rewards that we get, even with the stress that comes with it, but that it is not everything, and it will never be everything for a healthy person.
Thank you. And I appreciate you both made sure to include those silver linings, because I think there's a lot of negatives that we can identify in this situation. So I appreciate it. Next, we have Adam Weber. Adam serves as the Deputy Director of the Conviction Integrity Unit of the Cook County State's Attorney Office in Chicago, Illinois. He began his prosecutorial career as an Assistant State's Attorney in Chicago, where he handled misdemeanor and felony cases at all stages of proceedings. Between 2008 and 2018, Mr. Weber served the international community as a prosecutor at the International Criminal Tribunal for the former Yugoslavia. Adam is also the director of the Trial Advocacy LLM program at Chicago-Kent College of Law. Thanks.
Thank you, Kelly, and thank you to the section for having all of us. It's always a great pleasure to follow great panelists. So during the course of my presentation too, I'll probably echo many of the things that Elizabeth and Joshua have already said. There's some themes I think are constant, regardless of the jurisdiction that you practice in, that have impacted us in several ways during our criminal trial practice. Currently, I'm the Deputy Director of the Conviction Integrity Unit at the Cook County State's Attorney's Office. So my unit investigates and reviews claims of actual innocence that are made by people that have been convicted of crimes, felony crimes, on the basis of new evidence. So my unit, the attorneys that work for it, the investigators that work with us, we also have a forensic specialist that is with us. We are largely out of court in our day-to-day assignments and the things we do. We are very active from an investigation standpoint in looking at cases, investigating what the new evidence is and the forensic. So in a simple way, just the initial way that COVID impacted us is that we were all in a place where we had to keep some greater distance from one another. So I think that whether it's meeting with clients, interviewing witnesses, talking to people, investigating crimes, the circumstances that evolved with COVID impacted us in terms of our ability to get out and actually talk to people and investigate some of the claims that came before us. The Cook County State's Attorney's Office is the second largest prosecutor's office in the country. There's 700 attorneys that work for it. It's a big operation. So when COVID times happened in March and April last year, I think it was a big transition overall for our office. I mean, we're assigned to many different courthouses. There are assistants that are of all different levels with different responsibilities that have to communicate, that have to go to different courthouses. There's a large volume of cases that are going through the system. And so most of this happens with us being physically present in the courtrooms and filing things at that time. And we really count on our day-to-day presence in the courtroom to handle the volume that goes through. So when we were then suddenly forced out of the courtrooms. I do think that there were some initial barriers. Access to technology. You're taking a large office, suddenly having to retrofit a lot of what we would do in person with being able to do with computers or through shared network systems. So the office really had to integrate, I think, and did so in the first month and a half of between like March and by the end of April last year, really going to more online platforms, things that we could do to share information. All of us treasured our hard files and actual physical copies of things, and we had to implement much more scanning of documents and sharing things with one another electronically. So that was a process, and that was a process just not only on immediate cases, but sharing amongst units, sharing things between different assignments also became a big challenge. A unit like mine, we were dependent on getting documentation from a whole source of whole sort of different sources, whether it be from our warehouse or from the courtroom assistants, from law enforcement, from the crime labs. So we really had to engage in a process of working out ways that we could share that information and documents between all of us. As you can imagine, my unit, we look at claims of actual innocence, people that are making a claim of wrongful conviction. We get a large, the amount of work that comes into my unit is reflective of the general volume of cases that go through Cook County. We get a lot of claims that are brought to us. So one of the things that we did, and we felt it was important to do at the outset of COVID, was to really look at what was currently on our plate and to prioritize a little bit more people that were in custody. You had people that are suddenly facing health considerations from being in jail. There's concern nationwide about jail populations. And I think that a unit such as my own very much then quickly started factoring in, if someone is in custody and they have a claim of innocence, we prioritize those claims if we had stuff going on to see what we could do to reconcile and really what barriers we had maybe to further investigations to really look at them and see how we could complete them during this time. That once that was factored in, I think that after a couple months, we accommodated, we adjusted. We were able to then, I think after that initial first few months of shock of adjusting as an office and as a unit to handling the COVID times, really by mid to late summer, I think that we had gotten into a process and adapted as a unit and largely as an office to carry on many of our functions the way we had before. To echo something that Elizabeth talked about, I think that Cook County is no different in terms of how our workflow was impacted. Crime is up, cases are still coming in. There is not as efficient means of adjudicating cases through hearings and trials. So there's a backlog that has resulted. So I don't think that our jurisdiction is any different in a lot of that way. I think that I would basically repeat most of what Elizabeth said in that respect in terms of what our backlog has come to. Recently, Cook County has tried to do jury trials. The first jury trial went a couple weeks ago. It was in person. Couple courtrooms have been retrofitted in our old courthouse to try to accommodate some level of jury trials. And I think that they're on a very staggered basis now through glass paneling, distance, allowing instead of our normal jury deliberation rooms, entire separate courtroom for the jury to deliberate in. And I think that from my understanding, it went okay. Jurors showed up. There were safety precautions that were put in place. I think there was a high degree of attention and thought that was put into it for many months, actually, to discuss it. Of course, getting things back up with the volume that we're dealing with, even if one jury trial is going a week or just a couple a week, that's still creating a huge backlog that we're not able to fully address. I think most jurisdictions, Cook County included, had to address the Speedy Trial Act in some way, shape, or form. I think that at first, this was a really unknown in Cook County. We didn't know what was going to happen when stuff first came in. I think that the judicial system and eventually the Illinois Supreme Court did a nice job of issuing orders in a periodic basis that clearly addressed the Speedy Trial Act and how it was going to function. So they didn't just give one order early on and just say that's what's lasting through COVID time. They really did a periodic assessment along the way. And I thought that the level of communication with that, especially amongst the practitioners in our court system, was quite good from the judiciary, and really, I think, helped both prosecutors and defense attorneys really have a good understanding of what the circumstances would be, not just for at least a 60-day window, sometimes up to 90 days, which can encompass several court dates, and be able to communicate it, discuss cases, and go back and forth with it. The county set up basically Zoom hearings, so you can call in on the website. Everyone can click into a Zoom link to attend their court dates, lawyers and defendants, and that's primarily how that's worked. It's also, there's a YouTube live, so if you want to watch the court proceedings for the public, you can watch via YouTube and see how the court cases are going at a given time. I would echo a lot of what Elizabeth and Joshua said about the impact on young lawyers. A couple of things about that. On a plus side, I think that young lawyers have also had an opportunity to engage in a lot more training that is available, that people have been very aware of. Now that we're not doing everything all the time in court, the amount of webinars and things such as this have increased infinitely. And so where the all of us wouldn't maybe necessarily always get together to share our thoughts on things like that, there is a much greater increased opportunity for young lawyers to attend things such as this, or to attend webinars and learn a bit more from really great experienced people that are out there doing a lot of different things. So I would always encourage young lawyers to do that. I totally agree with what Elizabeth said from a networking or from just kind of a mentoring standpoint. It's fair to say that, of course, because you're not sitting there on a daily basis, that the same level of communication that'd be going on necessarily for young lawyers isn't necessarily the same. But I also agree, don't worry about that. You've got time, and that people, and I know definitely supervisors, myself included in my office, care deeply about the development of our attorneys as they go through the system and really invest a lot in them. And so I think that as a supervisor, that has forced us to adapt a little bit in how we are providing that mentoring and how we are sharing and communicating knowledge with stuff. It's a balance, especially when you're in the office and physically together, that can very naturally occur in a lot of situations, whether it's sitting together, as Joshua mentioned, on an arraignment or during a motion or something of that sort. When you're away from one another, I think it is important not to be calling up your subordinate at every 10 minutes, being like, everything okay? Everything, how about now? Now, everything okay? Anything? No, and I think that you do have to respect the space, but you also have to make sure you are making yourself available as a supervisor to your subordinates so they know that you are there for them. to ask any questions, to talk about things, and to make sure that they are also getting, that they're not left with the feeling of being left alone on an island on some Zoom call, so they don't have anyone to talk to. So I think that, from that standpoint, there is, and I think that we have tried as best we could under the circumstances to try to provide mentoring in that way to people. I think overall it's good, especially good for even development of some supervisory skills, because I think that you have learned to be much more attentive to allowing that flexibility that Joshua was talking about, to know the balance and work through the balance of supporting the people that work for you, but also being there and still being available for everyone that you are working through. In terms of managing the stress, I do think it's important to be aware people are going through stressful times. It's a law practice. Things are going on. Criminal trials, criminal proceedings involve significant impact to people and their lives, the defendants, everything that goes on. Judges are doing their best to manage what is an increasing a backlog of cases. And there are stresses that are involved. Then on top of that, with us adjusting to COVID time, I've got 2 little kids. My wife and I are now balancing being at home with young kids, the youngest being 6, with trying to encourage them to watch the iPad and follow class and do everything along those lines. But at the same time, I'm attending meetings like this or talking to my colleagues about very important matters. And so I think that it's important to understand and have flexibility that now in people's lives, there are things going on that they're adjusting to by having kids at home, by having maybe not as much contact with other people that they usually have. Feelings of isolation, I think, are really important to be attentive to. So I think that all of that feeds into a circumstance where, flexibility, not only in terms of when work is getting done. I actually have seen 0 slippage, and actually overall, I think people have been awesome about the quality of work that have come through. So I've not seen that the remote aspect of that has negatively impacted the quality of people's work. People have pride in what they do. They care about it. They've dedicated their time to doing it. What I do think is important in that context to make sure that that quality continues is not to burn them out by being overly inflexible on deadlines, times, sweating the small things, to really be more understanding in that regard. I think for us in Cook County, there are a lot of silver linings. I think the biggest one is that a rather large office that has many moving parts, it really forced us to transition to technology. It really has forced us to make that leap, to handle things in a scanned format. I think that it has forced everyone, whether they're young attorneys or older attorneys, to become more adept at communicating with one another and basically coming into the present in terms of their use of technology. That's really my basic thoughts. I wish you all the best of luck with the rest of your time here in COVID.
Thank you. So it seems that we have these 2 different balances that keep coming up. There's the fairness and efficiency, but now also the professional versus personal, which I think across the board is just so hard for everybody. And so to not spend any more time, we have Arthur Trolley as our final speaker. Arthur is an experienced international litigator. From 2010 to 2017, he served as a prosecutor at the International Criminal Tribunal for the former Yugoslavia. More recently, he has worked on teams filing submissions before international courts and the US Supreme Court, and litigated, investigated, or written on serious human rights violations. Arthur is the co-chair of the ABA International Criminal Law Committee and a member of the American Bar Association's International Criminal Justice Standards Advisory Group. Thanks, Arthur.
Thanks, Kelly, and thanks everyone for having me. Obvious caveat to start with, I'm speaking just for myself and not for any past, present, or future clients or institutions. With that said, I think I wanted to start with what is kind of the joy and the terror of going last on a really great panel, which is trying to think of what you're going to add to what everybody else has already said when they've taken a lot of the great points that you had prepared and were proud of yourself for thinking of beforehand. And so what I wanted to do is kind of try to bottom line a couple of different areas from my perspective. And first for how this affects young lawyers. And there are a couple of things that I want to say about that. And one of the things that you heard a couple of times, I think, is particularly in Joshua's presentation, was talking about not knowing what to expect when a particular thing happens. And one of the things that I think is true for a young lawyer is when nobody knows what to expect, that's an equalizer for you. And it's an opportunity to more quickly add value. And it being an equalizer doesn't mean that you're suddenly at exactly the same level as everyone else. Examining a witness on Zoom is more like examining a witness in a courtroom than it is like taking the bar exam. But it's a new skill that everybody is to some extent learning at the same time. And it's an opportunity for you quickly to develop expertise in it. And it's an opportunity also in your office for you to be the person who has done Zoom hearings and have developed that skill set and developed some reps and developed practice in that area. And I think for young lawyers, that's a real silver lining, being able to do that. And it's one that will go forward. To some extent, we're talking about things that we hope we're on the back half of, right? We're talking retrospectively about the past year as we start thinking about getting back into courtrooms as we move towards something approaching full vaccination in the United States over the rest of this year. But those changes that people talk about maybe sticking around are changes where for a while, you're going to be among the first people who did them. And you'll have as much experience as everybody else. And having built those skills will continue to be important for you. And you'll have an opportunity to look at them and think about, okay, which of these are working well for our clients and kind of shape in an objective way that's free of maybe an institutional bias towards the old way, which of them we will keep. And I think that's an advantage as well. And the third thing that I want to note in terms of effect on young lawyers, a couple of people have talked about training opportunities, and I think that's great. I think the thing I want to accentuate, and I apologize, one of the panelists said something similar, but the thing I want to accentuate is the requirement that you be a little bit more creative in your networking and your seeking out of mentorship opportunities, because it is great that we have more events like this available, but of course you don't have the opportunity to catch Adam for a cup of coffee or catch Elizabeth for a cup of coffee in the lobby after this when we have a reception and everybody eats the sandwiches that the law firm provides and drinks Starbucks together for an hour before we all go home. And so making that proactive effort beyond showing up at an event to make the connections that are necessary for you to move forward in the field is, I think, particularly important. And then finally, I think in terms of young lawyers, just to echo the way that this is kind of reinforced and if anything increased the importance of the litigation technology that we're using. And young lawyers don't have an automatic advantage in this regard. Adam's got a couple years on me, I think, and when we worked together, his facility with our litigation tech was probably a bit better than mine, and I think better than anybody else in our office either. But it's a skill where you do start off on more of a level playing field and have the opportunity to build those skills and demonstrate your value very quickly. So with that kind of bottom line, what I want to do is talk a little bit about, from the perspective of somebody with a perspective that, with a practice that touches on some of the international criminal courts, talk a little bit about how they're handling this and thank one of my interns, Jordan, who I think is on the call today, for helping pull the information together to do this right. And as a kind of background, these are courts where witnesses and lawyers have to travel to court, sometimes from countries that may have pandemic restrictions on travel to the country where the court is located. Individuals may be detained if they've been convicted and transferred to serve their sentence in third countries, and the court may have to check on the COVID measures in those countries and satisfy itself about them, as we've seen courts do. And this puts the field at significant risk of COVID challenges, and that's impacted lawyers across the field, myself included. For one obvious example, I've been traveling a lot less. I speak with clients on the phone and on web conferences like this and correspond with potential clients. I've been in an office less than 10 times in the last year. And for somebody who was already working remotely, more remarkably, I haven't been on a plane in 14 months. And by way of comparison, the fourth quarter of 2019, I crossed the Atlantic 6 times in each direction. And so it's a really significant lifestyle change and in many ways benefit to not be doing that quite so much. So in terms of how this is affecting these courts, I think access to technology becomes really important. We saw at a recent Kosovo Specialist Chambers Status Conference, for instance, that all the defendants were participating remotely in the proceedings rather than present in the courtroom. The court had the ability to arrange that. But in a global type of practice, sometimes you see different effects on people working from different areas. For instance, last summer, the International Criminal Court had online hearings for the candidates for chief prosecutor. And we saw the candidate who was based in Africa had internet connectivity problems, we think, that interfered with the hearing and created some difficulty making herself understood. And I think that was a real shame. And it's something that courts that are dealing with lawyers from a lot of different places in the world have to think about and anticipate. When you look at the court's annual reports, you see, I think, a couple of big takeaways: delays in investigations, postponements of courtroom proceedings, and the need to innovate to hold them. And then one consequence, which I hadn't anticipated in advance, which is steps forward in tracking fugitives from these courts. And a quick note on each. Delays in investigations are obviously particularly likely when you need to fly from The Hague to, say, Kigali or Cox's Bazar to meet witnesses, because there are more ways delays can arise. Right? You need to quarantine perhaps before flying to go to a new country, perhaps quarantine upon arrival in a new country, respond to different countries' outbreak timetables and crafting your own precautions. And we've seen the impact in, for instance, one of the most discussed ICC investigations here, one that involves mostly allegations against the Taliban, but also a small number of allegations against US personnel over events in Afghanistan about 18 years ago. When Afghanistan filed a communication to the prosecutor asking the ICC to defer under the principle of complementarity, because it was handling the cases itself, the prosecutor noted first that Afghanistan was going to need a couple of extra months to get the information together due to the pandemic, but essentially also noted there was no hurry, saying, quote, "The prosecutor is not taking active investigative measures in relation to the scope of the letter and annex submitted by Afghanistan at this time due to the COVID-19 outbreak." A year later, Afghanistan's deferral request is still under advisement, and in a filing 366 days after it initially notified the pretrial chamber of Afghanistan's communication, the prosecutor referenced the pandemic twice in a 4-paragraph pleading and noted it's still trying to facilitate Afghanistan's request for an in-person meeting to discuss the matter. And second, on trials, most of these courts already had something that I understand is not particularly common in domestic trials, which is public live streams of the proceedings. And one of the things that meant is it was possible to preserve the public nature of courtroom proceedings without preserving public attendance. That's been important in getting back into court in a way that's consistent with what we understand to be rule of law principles. And that made it possible to adhere to the principle of a public trial. But there were meaningful postponements last year, like in domestic courts around the world. For instance, the mechanism for international criminal tribunals had one case in court when the pandemic hit, the prosecution of 2 of Slobodan Milosevic's intelligence chiefs for their alleged involvement in a joint criminal enterprise to permanently forcibly remove Croats and Muslims from Serb-claimed areas of Bosnia and Croatia through the commission of a variety of crimes. On March 11th of last year, they adjourned court, and the presiding judge noted they were scheduled to reconvene the next Thursday, March 19th. The next courtroom transcript available is from September 1st. And that's almost half a year later, of course. Last March, judgment was anticipated by the end of last year. As it stands, closing arguments were held earlier this month, about 2 weeks ago. So you see the effect of the postponements in a case like that as well. The other proceedings in front of the mechanism were also delayed. And then third, on fugitives, and this is one of the big, I think, silver linings from an enforcement of justice for atrocity crimes perspective, you see real accomplishments over the past year from a few of these institutions in fugitive tracking and in apprehending some people who'd been on the lam for a long time. And Adam and my old boss, the MICT chief prosecutor, Serge Brammertz, talked about the dynamics in an interview after the MICT arrested its most prominent remaining fugitive, Felicien Kabuga, who's charged with being a prominent financier of the genocide in Rwanda, as well as other forms of involvement. And the prosecutor noted it's harder to do in-person surveillance because it's easier to get noticed doing surveillance during a lockdown. But there are also advantages because other people, including fugitives and their support networks, are moving around less, so it's easier to nail down information about where they are. And the impression from reading what he said is that the MICT staff found ways to make the pandemic a net positive for their hunt for Kabuga, which may have been the single biggest development in international criminal law last year. And so I think those are the key kind of dynamics that we see in these courts and effects over the course of the last year. The last thing I want to say on this point is there are a couple of new international institutions, not strictly speaking courts, but kind of clearinghouses for evidence for areas where there are allegations of very serious atrocity crimes in Syria and in Myanmar. And what we've seen there, because they're very young institutions, less than 5 years old, both of them, looking at their reports, you see particular challenges getting staffed up, onboarding people, and because they're clearinghouses for evidence, as well as having some investigative capacity themselves, challenges working with interlocutors who are doing evidence gathering around the world and who may have different types of pandemic effects depending on where they are and with whom it may be difficult to hold in-person meetings. So I think that's what I have to add. And Kelly, if people have questions, it'd be great to hear those now.
Yes, thank you. And you definitely did have some interesting things to add, and I appreciate the international perspective. So we only have a few more minutes, but we did get a couple of questions. So I think that we can probably combine these two questions. One is directed toward Elizabeth, and that is, has the pandemic provided an opportunity for Howard County to re-examine sentencing practices? And so talking about alternatives to incarceration in light of health issues due to COVID. And then also what type of research or alternatives might be used for Zoom meetings. I think this would apply probably also for any of your work or practices, but since it was directed to you, Elizabeth, I'll start with you if you have anything to add there.
So maybe I'll start with the sentencing question and then open it up to everybody else for input on the other portion. I am always open to sentencing alternatives. We do a lot of drug treatment programming and are always looking for different things to consider outside of incarceration. That to me didn't change as a result of the pandemic. What I can say is that we had significant bail review filings and habeas corpus filings based on high-risk inmates, and that resulted in a lot of people being released. I have a very small fraction of inmates that remain incarcerated as a result of COVID health-related issues in Howard County. But that's something we're always considering still now. But the last point I'm going to make on that is that, the treatment programs have also been affected by COVID, and having new people enter treatment or leave treatment or change treatment has been a difficulty that I've noticed from our defendants as well. So it's all been a balancing act, every aspect of this, and I think it will continue to be so.
Thank you. Would any of the other speakers like to add something to that?
Yes, hi. I actually, I think it's another of the silver linings of the pandemic is acceleration of trends to decarcerate and to look at alternatives. I have spent a lot of time in the past 13 months doing compassionate release motions in the federal system. And I think in two ways. One is that it has brought attention not only to conditions within correctional institutions that judges just are not made aware of, because once the sentence occurs, there's really no basis for litigating that in front of a sentencing judge. But the second part is also revisiting sentences. So just to give you an example, in the Southern District of New York here, in a capital trial that the jury imposed life without parole in, I think, 2000 or 2001, in a particularly grisly homicide, and two defendants had their sentences reduced to 35 years and 30 years because of their transformation in custody, even while they had no prospect of release. So I think that kind of second look, which a lot of statutes are trying to address and a lot of jurisdictions are trying to address independently, but I think this has given an opportunity for judges too to say, hey, you know, maybe that wasn't necessary. And even the Second Circuit, in a case affirming a long prison sentence for a young MS-13 defendant in a homicide, said, you know, they should bring back parole. What is the point of warehousing? You know, so these I think are salutary effects.
Thank you.
I guess I'll just chime in from the Cook County perspective. Yes, our county, I think, was very well along the way in terms of developing a lot of alternatives to incarceration. So I think that to the extent that there were different mechanisms already in place in terms of alternate sentencing practices, I think that there were many that were available to it. I think a great point that that Joshua brings up is I think Illinois, just like other states, they had statutes in place. And it really, I think, as a silver lining, not only focusing more attention, making individuals on all sides of the system more aware of alternative sentencing practices and other options, I think it has caused people to go back and look at their statutes and really take a hard look and see, are the things we have in place the things that that are going to allow for the right degree of going back and really looking at sentences. I think that you know, a lot of sentencing practices are there. There's a lot of statutes that address how to sentence people, but I think that aside from clemency or some type of parole, which also can be very statutory based, the circumstance that we've now found ourselves in is that there are petitions being filed that are seeking some type of relief and reduction of sentence that necessarily don't fit within the boxes in a given statute. So I think it has caused that.
Thanks. And Arthur, now again, would you like the final word?
I don't think I have much to add. I think, you know, in this specific regard, the international courts have had to look a little bit at how countries where sentences are enforced are handling this, and we've seen them do that. But I think because of that different kind of sentencing enforcement process, it's not exactly like the domestic process in this regard.
Well, I regret that we don't have the reception that Arthur talked about, because I have my own questions for all of you, but want to thank you so much for taking the time to speak to us today. You all had a lot of very interesting and insightful things to say, and I don't know if you have any final closing housekeeping remarks.
I do. Thank you, Kelly. Thank you so much to our panelists today for your excellent comments and for giving your time, especially to talk to young lawyers today. So we really appreciate it. And thanks to all the audience members for tuning in and for your participation and great questions. If you're interested, the criminal justice section has two great events next week. May 4th, a non-CLE webinar, Guantanamo and Beyond, a panel discussion on military commissions, torture, and the way forward. And we're also hosting a documentary screening and discussion on May 6th of the documentary Ernie and Joe, Crisis Cops. So you can find more information about criminal justice section events on the section's webpage, and also about upcoming section of international law events on their webpage. If you're not already a member of either or both of those sections, please consider joining based on your interests. And again, thank you so much for joining and listening today, and we hope to see you soon at another ABA, CJS, or section of international law event. Have a good day, everyone.